The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters as well as some landlord-tenant issues. Now, today we're going to talk about what someone can do if a will existed but is now lost in Iowa. An important part of estate planning is to keep your will in a safe and accessible location. Unfortunately, there may be some instances where the will is lost, destroyed, or otherwise not available in the probate process. We're going to cover what exactly a lost will is and what can be done about it. Now, what is a lost will? In Iowa, a lost will must have originally existed in writing. It must have been properly executed under Iowa law and never revoked. Now, will an Iowa court consider a lost will? Iowa law does allow courts to consider lost wills. Courts, as always, wish to carry out a decedent's true intentions if possible. However, there is a presumption that if the will is not available, it has been revoked or canceled by the decedent. This is called presumption of revocation. The presumption makes introducing a lost will into probate difficult. The proponent, the person advocating for the lost will to be admitted, must prove several things to overcome this presumption. Now, what does somebody need to do to establish a lost will? To establish a lost will, the proponent must prove by clear and satisfactory and convincing evidence, i.e., no serious or substantial uncertainty, first, due execution and former existence of the alleged will, 2, that it has been lost and can no longer be found after a diligent search, 3, that the presumption of destruction by decedent with intent to revoke it arising from its absence at death has been rebutted, and finally, the contents of the will. Now, what is due execution? The proponent must show that the will actually existed and was properly executed. Proper execution in Iowa means that it was in writing, signed by the testator, or the person in their presence, declare the document as their will in the presence of two people acting as witnesses, and have the witnesses sign the document in the presence of each other. Iowa recognizes wills executed in other states if the will is in writing and meets the execution requirements in that particular state. The person must be mentally competent at the time of signing the will. What evidence may a court consider to prove a will is lost? Due to the nature of these cases, parties usually must turn in circumstantial evidence to establish or refute a lost will. Circumstantial evidence relates to a series of facts that, or other than the fact sought to be proved. The person argues that because the facts and circumstances, the fact sought to be proved must be true. The court may hear testimony from people who witnessed the person with the will, spoke with the person about the will, or heard the person say the will was lost. The court may see an unsigned copy of the will, in conjunction with testimony that there is an identical version of the will that validly was executed. In one case, the court heard evidence that an unsigned copy of the will, with the word will written at the bottom, kept in the safest place in his home, was his will. To prove that the presumption of revocation has been overcome, the proponent may introduce into evidence of the decedent's declarations by circumstantial evidence. The court also considers the decedent's relation to the people that they made the declaration to. Declarations made to disinterested persons not taking under the will have more weight than statements to interested persons. In other words, if you are supposed to get something in the will, you might have incentive to fabricate something. But if you have nothing to gain in stating that there is a will, there is going to be more deference given to your statements. Courts have also considered situations where people with access to a supposed will had adverse interest to the will. For instance, if a child was cut out of the will but comes into possession of the will. An adverse person having access to the will weighs in favor of a finding that the decedent meant to revoke their will. This is because the decedent intended to main their will, probably would not place their will with somebody who is motivated to destroy or alter it. However, this is only one factor that the court considers, and there may be reasons why such a person could gain access to the will. Ultimately, rules involving lost wills can be complicated. It's often preferable to have a valid copy of the will available and to be clear when creating, modifying, or revoking the will. If you have any questions about your will, feel free to reach out to us at our firm. Thank you very much, and have a nice day.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.